So, Mr. Anderson, would it help if we all logged off and logged back on, or is it better for us to stay on and wait? Oh, wait, it looks like apparently I've got a message, it's going now. So can somebody just confirm that the YouTube Live link is working? If somebody can log on or knows somebody who's logged on, I want to make sure it's working. Mr. Wooldridge, yeah.
It appears it's working. It just, for some reason, the interface has somehow changed. Before, there used to be a bunch of tiles of our previous hearings, and the one in the top left corner would have a symbol at the bottom indicating it was live. Now you have to scroll a bit further down the page and you'll notice a section called Live Now. And if you go to that section of our YouTube page, you'll find the streaming.
Okay, thank you for that clarification. All right, well, I'm just going to click on it here and see if I can get it. Okay, well, I'm not getting it right now, but if you're sure it's on, we'll go ahead and start. So I apologize for the delay. I'm going to state for the record again, and hopefully it's now on the YouTube recording as well. It's February 2nd, 2022. This is the afternoon session on the Administrative Hearings Office hearing on the prosecution team's draft cease and desist order against BlueTriton Brands, Inc. And this was a continuation of the hearing from this morning, so I'm not going to go through all the introductions. I just before we had the YouTube problem, Mr. Lowe gave a clarification about the Headwater Springs. I'm not going to ask him to repeat that. If somebody on the YouTube channel needs to have that, it was a couple of minute segment, we will be posting the Zoom recording to our AHO FTP folder, and it can be accessed there. My understanding is the Zoom recording does have that. So with that, let's go forward. I think that was it was just a couple of questions. And with that, Mr. Petroselli, please proceed with your questioning of Mr. Lowe, and we'll go forward that way.
Okay, thank you. Mr. Lowe, I wanted to ask you about some locations, and if we could put up, I'll ask for two, SOS 24, page 10, and SOS 49. And the reason I'm asking for two is because these are both maps, and I want Mr. Lowe to use whichever one he believes he can best identify locations for us. And for each location, that may not always be the same map.
All right, let's start. I'll ask, we can only post one exhibit at a time.
Okay.
So I'll ask my staff to post SOS 49. That was the exhibit Mr. Lowe testified the most to yesterday. So let's start with that, but then Mr. Petroselli or Mr. Lowe, if you think we need to shift over to SOS 24, page 10, we may do so. So with that, just give my staff a moment and we will do our screen sharing with that.
And I'll try not to ramble, you guys. I'm trying not to.
All right, so Mr. Petroselli, we have SOS 49 on the screen. Please go ahead with your questioning.
Yeah, and then can we switch over to, Mr. Lowe, do you recall this map?
Yes.
Okay, and then can we shift over to SOS 24, page 10, just so we can see that Mr. Lowe also recalls that map?
Yes, just remember that it's the next page as well, and then it only goes down to the East Fork. It doesn't go beyond the East Fork.
Okay, so I want you to use whichever map you believe is most helpful for you in identifying locations.
And it's going to depend on your question.
Okay. Okay. So for spring 1, in your experience in the forest, if that spring were naturally discharging flow, is there anything that you would understand to be a stream channel that it would discharge flow into?
Yes.
Okay.
And let's look at the.
And I was going to ask if you could identify that on a map for us.
What's great is on the SOS 24. Is that what it is? 24?
Yes. So
what's great about that is they've done all that work for us. So it's all there if you look at the map, and I can
Okay.
explain where it is.
And if we need to zoom in or scroll to a certain location, please talk us through that.
Okay. Okay. So what questions do you have about this area? This is a good view right here.
So for spring 1, where you indicated, where is what you would understand to be a stream channel where spring 1 would discharge flow?
Yes, and as you can see there, they've marked the stream channels. That green that you see, the wiggly line, that's a stream channel there below horizontal boring 1, 1A, and 8. So the borehole is the green.
Objection.
Wait, excuse me, Mr. Lowe, let Ms. Brady state her objection.
We've repeatedly referred to they. And I don't know who they is.
Okay, well, that wasn't a problem with the question, it was a problem with the answer, but maybe it would be good for Mr. Lowe for you to, when you say, instead of saying they, say who you're talking about, and then go forward that way.
Okay, let me get the exhibits here. This is
Hello,
the Halion.
When you say they, do you also mean spring 8 in addition to spring 1?
Oh, I thought they meant
Objection.
Yeah, Mr. Petrozelli, you better start over. Try
Okay.
again, please.
Mr. Lowe, can you identify on this map what you believe would be a stream channel to which spring 1 would discharge flow if it were flowing naturally?
Objection.
Yeah.
Time.
Okay. Mr. Petrozelli, when you say if it were flowing naturally, do you mean if there were no diversions? I guess, Ms. Grady, I think the question basically is if the diversion stopped, would there be flow? So I think that's the timing. So I'm going to overrule the objection and allow him to answer.
Yes, there is a natural drainage there, and it would flow in that drainage and to that drainage if it wasn't capped at the spring location. And there's three or four different boreholes and tunnels there. So the spring has been totally obliterated basically, and it's now dry as a bone. But if there was water running from the spring like it did naturally, it would run down the stream, and it's shown in green right there.
If we were during the site visit, do you believe you would be able to identify that?
Yeah, I think at all these sites, you could identify where the flow probably went. It's
Okay.
really hard to tell because it's been so modified, every one of them.
So if Mr. Lilly during the site visit asked you, Mr. Lowe, can you point out the stream channel that spring 1 would naturally discharge flow into, you believe you would be able to do that?
Yes, and I'm not going to be able to be there because of medical issues. So, but Amanda Fry, Hugh Bilecki,
Objection.
have been there. Okay, sorry.
Okay. So Mr. Lowe, for spring 8, in your experience in the forest, if that spring were also flowing naturally, is there anything that you would understand to be a stream channel that the Springs flow would discharge into?
All of those 1, 1A, and 8 all drain into the same stream channel and always did.
Okay. And is it that same green line on the
Yes.
map on page 10 of SOS 24 that you identified for Spring 1?
Yes.
Okay. So for Spring 3, so shifting over to Spring 3, actually, let's make it Spring 2. So for Spring 2, in your experience in the forest, if that spring were naturally flowing, is there anything that you would understand to be a stream channel that the springs flow would discharge into?
Yes. And if you want to see that better, we could get another Haley map. Let me tell you that this was what the Forest Service and BlueTriton decided to do to monitor these locations. That's where these Haley publications were done for. So
do you know what map?
Okay,
that might be?
excuse me. I'm trying to keep everything going here. Ms. Belenke has raised her hand. Please, Ms. Belenke, please go ahead.
Yes, I just wanted to clarify because the map that's showing on the screen and which Mr. Lowe has stated there's like a green wiggly line. When you look at the actual exhibit,
Objection.
can I finish my statement?
No, you may not.
Okay.
That is getting to the point where, I mean, I've got to try to maintain some control over this process. Wait, let me finish. Excuse me. Ask your questions when it's your turn on cross-examination.
That's fine. That's
the
fine.
best way to do this. All right, so Mr. Petrozelli, back to you.
Okay, Mr. Lowe, do you know what exhibit that a preferred map might be in?
I think they were in your guys' exhibits, and it's another Haley Aldrich map. It's the same map, but it's 2 years later. It's their first year of monitoring.
All right, that's answering the question, Mr. Lowe. Please stop. So, Mr. Petrozelli, please go on to your next question.
Okay. Can you so Mr. Lowe,
Yes.
so I think it is, so for Spring 3, in your experience in the forest, is there, if that spring were naturally flowing, is there anything that you would understand to be a stream channel that the spring's flow would discharge into?
Yes, but I need to qualify all these questions you're asking. When you guys go out there and look at this, you're going to see that this is not the kind of ground where spring flow would create a channel much. It's so much rock. It's rock on the side of a hill. And so, and some of Roe noted in some places too, that the water was actually flowing underneath the rock that had come off the cliffs and talus slopes. So they could see the water, hear the water, but they couldn't actually see a channel. And that's what's happening in here, a lot of it. But even though Haley and Aldrich, in their monitoring that they're doing for BlueTriton, identified every one of these having a stream leading down to the common confluence. And so, yes, they all have springs that lead to and run in a channel. Even though that channel may be rock, they still flow downstream and get together at the common point at the bottom of this photo right here.
All right, so Ms. Stoddard's hand is up. Ms. Stoddard.
Just in the interest of preserving the record, could we be told what page we are looking at presently so that the references are correct?
Yes, this is SOS 24, page 10.
I believe it's actually page 12.
Okay, well then it's, let's see if we can tell. I don't know if, Ms. Mullen, is there any way you can minimize out so we can see the page, the PDF page number? There we go. All right, thank you, Ms. Doty. This, in fact, is page 12. We're trying to zoom in so we can see the photos better, but then we lose the page number. So thank you. All right, Mr. Petroselli, next question, please.
So, Mr. Lowe, for spring 7, in your experience in the forest, if that spring were naturally discharging, is there anything that you would understand to be a stream channel that the spring's flow would discharge into?
To answer that, let's go over to the right to where we can see spring 7.
Okay, we'll try to scroll to the right. I don't know if it's on this page or the next page, but let's scroll out and scroll to the right if we can.
Okay.
Oh, there we are. Okay, so I do see horizontal borings.
Yep, 7. That's it.
7, 7A, 7B, and 7C. So go ahead and answer the question now that we have that on the screen.
Okay. Yes, there is a channel there, and on the Haley, it's over there kind of to the right where that cleared space is, but most of that is pipeline clearing. But there is a channel over there, and the records indicate that the water did flow down and into a channel. That one's harder to see, but I'll be there when we go out there, and we can do our best to try to find it. Like I say, these Headwater Springs don't create a big channel. They're not running fast enough, and the ground's not soft enough to create a big channel. So, but they did run downstream, and they did get to the creek.
Can we zoom out a little bit? I have a question. I want to. And this is SOS 24.
Yes, we're still on page 12 of exhibit SOS 24.
Okay. I see. Can we go up to page? I was looking at page 10, but if page 12 is better, that too. So, and then, Mr. Lowe, for springs 10 through 12, in your experience, have you ever seen those springs discharging visible surface flow?
Let's zoom in on those if we can.
Okay. Can you tell us where to focus on this map?
Yeah, go downstream. Keep going further. They'll show up as springs.
Yeah, they're right down at the very bottom of the page. So let's see if we can find
Yes,
them
there we are.
Okay.
And maybe now zoom in a little bit. Okay, good. Thank you. All right, go ahead, Mr. Lowe. Why don't you go ahead and, Mr. Petroselli, just ask your question one more time now that we have it in front of us.
Okay. Thank you. So Mr. Lowe, in your experience in the forest, have you ever seen those springs discharging visible surface flow?
I've never seen it because I've never been there. Like I said, I'm excited about the helicopter flight.
Yeah, that's fine. Just say you have
Okay.
not been there.
Okay, thank you. All right. Those are all the questions I have for Mr. Lowe.
All right. So I think next in our line of examiners is Ms. Belenke. Ms. Belenke, are you there? Okay, you may ask your cross-examination questions of Mr. Lowe.
Thank you. Mr. Lowe, I'm turning back to your testimony, the Lowe one. On page 8 at paragraph 13.
Okay, let's, to help you out, help us all out, let's put up exhibit Lowe 1, page 8, and the top of the page.
Oh,
All right, please proceed with your question.
Mr. Lowe, in this paragraph, you reference historic surface flows in the second sentence, and then a little bit further down, you also talk about restoring the stream flows. So can you, based on your experience and in your professional opinion, based on the documents that you've reviewed and your experience of this area, take us through what you believe those historic flows would have been?
And Ms. Belenky, I don't want to cut you off, but he has already testified in some detail about this, and particularly regarding the Rowe report, and then in response to Mr. Petrozelli's question. So is there something new you want to ask him that has not already been covered?
Mr. Petrozelli's questions appeared to reference some future where the existing diversions would be stopped. I'm trying to clarify that this is what Mr. Lowe's view of the historic flows are.
Okay, I think, and part of the confusion is I think he testified some about that when he was testifying as a Story of Stuff project witness, and now he's come back again. But I'm going to allow you some leeway here for asking questions, but as I say, I think he really did cover a lot of this yesterday when he was testifying as a Story of Stuff project witness. But go ahead and ask your questions. And again, if you're going to ask about historic surface flows, I think you have to be specific as to what location you want to ask for about the flows. So please proceed.
Thank you. Mr. Lowe, yesterday you testified that about historic flows from the upper springs 1 through 4. Is that correct?
yes, 1 through 4, and that includes 8 as another borehole. So people talk about 1, 2, 3, 4, and 8.
And what was your estimate, just to clarify as we go through, what was your estimate at that time of the flow from 1 to 4 plus 8 of the historic flow?
My estimate's 100 to 150, a minimum of 100. Like Rose said, you could count on, I believe you could count on 100.
Thank you. And for the Spring 7 complex, can you tell us what would be your estimate of the historic flows?
Again, that one varied so widely. When they first tapped that spring, I think it was way up there, like 80 gallons a minute or something. And it kind of stabilized at around 30 or 40. So I say from 20 to 40 would be my estimate of the variation there that you could count on.
And for the springs that are 10, 11, and 12, what is your estimate of the historic flows?
I think the historic flows there were about 67 because we have good information on that. But that could have been a better year. So I figure 20% either side of 20 gallons per minute either side of that you could count on.
Thank you. I just want to make sure we have clear. I had one more question about your testimony in the paragraph 7, no, page 7, paragraph 12.
Okay, well, let's go back one page and we'll display that and scroll down to the bottom. Okay, go ahead.
In this paragraph, you state the second sentence states that much of the area had perennial flows before the springs were developed. Can you tell us the basis for a statement that Strawberry Creek had perennial flows before the springs were developed?
Yes, every document that I reviewed, including all the ones from Nestle that dealt, or BlueTriton that dealt with the history, all concluded there was perennial flows. There was estimates, and now there's a lot of dry stream bed there. So a lot of the estimates that were made were based on what they think it may have been like. And as it turns out, there would have been a lot less bare, dry stream bed had that water been allowed to continue to flow. And we can tell that now by looking at the various reports and the row information, which really kind of sealed it all, that yes, it was a perennial stream. There may have been a few sections that didn't have surface water. They probably would have still had riparian vegetation. Well, now there's huge sections, probably half of the creek that no longer has surface flows that should have them if the water had been allowed to continue.
Thank you. And I think that my other question was clarified because we were looking at a different page during your last, when you were being cross-examined by Mr. Petroselli. I think those are all my questions. Thank you.
All right, thank you, Ms. Belenke. So, Ms. Brady, do you have any cross-examination questions for Mr. Lowe?
You'll give me just one moment, please.
Yes.
We don't have any cross, thank you.
All right, I have one question. So, Ms. Mullen, please put up Exhibit Low 1 and go to PDF page 2. And scroll down to paragraph 5. All right, that's fine, thank you. I just have a question about the first sentence. So, Mr. Lowe, the first sentence states, I served as the lead biologist for the Forest Service on the massive MWD inland feeder project at Arrowhead Tunnel for a decade. Do you see that?
Yes.
All right, now, and I just want a short answer to this question. Where is the Arrowhead Tunnel located in relation to Strawberry Creek, as in north, south, east, west, and so forth?
The Arrowhead Tunnel is directly south of the hotel and south of Strawberry Creek. And it ran right along, well, very close to the San Andreas Fault and crossed Strawberry Creek, actually East Twin Creek. After Strawberry had already come in, it crossed East Twin Creek right below the hotel.
All right, and then where does it go? It has to somehow connect to the state water project. So from there, does it somehow run to the north?
It goes to Devil's Canyon, which is on the north end of San Bernardino. It's an old domestic water supply. It goes
Okay.
to there, and then it runs through the mountain through another tunnel that's been there for a lot of years to Silverwood Lake, and that's where it connects to the state water project.
Okay, so that part of the tunnel is then generally west of Strawberry Creek. Is that correct?
The tunnel that goes to Silverwood Lake is west. Yes.
Okay, and just in rough terms, approximately how many miles?
It was actually affected by the tunnel, though.
No, wait. That's
okay. I'm sorry.
Getting beyond my question.
Okay.
Approximately how many miles to the west of Strawberry Creek then is that part of the tunnel that goes north up to Devil's Canyon? I mean, just rough ballpark.
Probably 4 or 5 miles.
All right, that's good enough. I just wanted a general idea. All right, those are all the questions I have. Since Mr. Lowe was testifying on his own behalf, I don't think there's going to be any redirect, but Ms. Grady has her hand up. Go ahead.
I would just like to ask, I apologize, I said no questions, but I would like to ask if Mr. Lowe had any notes or written statements that he relied upon in answering the questions during his direct and cross-examination.
Yes, okay, we've allowed that for the other witnesses. So, Mr. Lowe, when you testified today, you've referred to various exhibits, but then did you refer to any notes besides the exhibits that are already in the record?
Many of them.
Okay. Well, our normal practice is if we were all in person the way we used to do in the old days, the attorneys could look at those notes if you referred to them during your testimony. So, Ms. Grady, I assume you would like him to preserve those notes. Is that correct?
Yes, and in particular, when we came back from the break, it looked like Mr. Lowe was reading some notes to assist in answering that first question in particular. I would like that one marked, please.
Okay, so you're not asking for him to produce them now, you just want him to preserve them. Is that correct?
I would like that one marked and produced, please. The rest of them I'd like preserved.
Okay, so Mr. Lowe, do you know what, it sounds like Ms. Grady's referring to one page. Do you know what page she's talking about?
And it was something I was looking at right before I testified, or what?
Well, that's what she said. I'll ask you, were you in fact referring to some page of notes when you testified? Wait, let me ask my question, please.
Oh, I'm sorry.
Were you referring to a page of notes when you testified beginning this afternoon after the lunch break?
I was probably searching for some through about 20 of them that I have spread out all over this place. And I may have found one and I have no idea which one.
For context, I believe it was when we were discussing the Headwater Springs and what he was referring to at that, using that term.
Does that ring a bell to you, Mr. Lowe, as to what page of notes we're talking about here?
I sure might have been looking for the map so that I could see how is the best way to explain the locations of the Headwater Spring.
All right, so Ms. Grady, how do you want to proceed?
I'll just ask that he please preserve all the notes that he's relied on today.
All right, so Mr. Lowe, please preserve all the notes you've relied on today. We've asked the other witnesses to do that, and it's appropriate. Just if you can put them in an envelope or file or something and just mark it, notes I referred to while testifying on February 2nd, that would be the best way to do that.
Can I ask a question?
You may ask a question.
I have 20 piles of notes here in my basement that that I run around to and try to find when you guys ask certain questions. So what, as far as what I use today, that's what she's asking, is the ones that I specifically use today.
The ones you looked at while you were testifying today.
Okay.
And we're somewhat on the honor system here, but I think everybody here is honorable. So
Sure.
We don't need the 20 piles, and we don't need things that have already been marked as exhibits. But if there are any other notes that you looked at today while testifying, please preserve those and put them in a folder marked notes I looked at while testifying on February 2nd.
Okay, all right, thanks.
All right, Ms. Gray, does that satisfy your request?
Thank you both.
All right, so Mr. Lowe, I assume you want to offer your one exhibit, which is Exhibit Low 1, into evidence, and you have basically verified that this is your testimony for the hearing today. So are there any objections to Exhibit Low 1?
Yes, Mr. Lilly.
All right, Ms. Grady, please state your objections.
We again object to the written testimony in its entirety on the basis that it is largely conjecture. There are allegations without identifying the basis of the support, hearsay and double hearsay without citation, and portions of it also go beyond the scope of this hearing.
All right. So do you have any objections to specific paragraphs or just the general objection to the entire exhibit?
Without belaboring a line by line, I think we have to just object to the entirety of the written testimony.
All right. So go ahead.
I would just state that quite candidly, it reads more as a policy statement.
All right. So this is, and that may be the case. There may be arguments in there. So this is how I'm going to rule. As far as whether the statements in the Low 1 are conjecture, I'm going to overrule the objection. I believe Mr. Lowe has established a foundation that supports his ability to make the statements in it. As far as the objection that it's beyond the scope of the hearing issues, I think there may be parts of it that are beyond the hearing issues. But rather than all of us spending our time going through page by page, paragraph by paragraph, line by line, I'll just say I'm going to admit it into evidence. But if Mr. Lowe or anyone else relies on it to make an argument, relies on any part of the exhibit to make an argument that goes beyond the scope of the hearing issues, then I will give BlueTriton the right of, they can have the right to object to it at that time. I think that'll be more efficient than trying to go through line by line today. So that will be my ruling on that. And then as far as hearsay, I did make a ruling yesterday on the Story of Stuff Project's exhibits for hearsay, and we'll do the same, have the same ruling apply here. If any party cites to hearsay statements in Low 1, then in their closing briefs, then I've said BlueTriton and other parties may have a second round of objections based on Government Code Section 11513 Subdivision D. So that same right will apply to Exhibit Low 1. And just to clarify, as far as the conjecture objection, I'm overruling that primarily on the basis of Government Code 11513 Subdivision C. So with that, we will admit Low 1 subject to those qualifications. And now excuse me, go ahead. Is there somebody else wanted to say something?
I just said thank you.
All right. Yeah, thank you, Mr. Lowe. I appreciate your patience and your focus on this testimony. Before we move on to other matters, I had two follow-up questions for Ms. Fry. I hope Ms. Fry is still there today. Uh-oh.
Oh, I'm here. I'm here.
There you are, Ms. Fry. When I was going through the exhibits, there were two that I just wanted you to tell me where they're taken. So they're pictures.
Okay.
Okay. Ms. Mullen, can you please put up exhibit FR 24?
Oh, right.
And just a reminder, Ms. Fry, you're still under oath.
Right.
Did you take this picture?
I did take this picture.
All right.
This
Stop. Let me ask my questions one at a time.
Okay. Mm-hmm.
When did you take this picture? or just best you know?
I could check. It's in my authentication. I believe it was 2015.
All right, that's close enough. And what is this a picture of?
This is at the Township 1 North at the Arrowhead Springs property.
Can you be any more specific?
At the base of the mountain near the Arrowhead.
Okay, the base of Arrowhead Mountain, is that correct?
It's near there. My friend knew the people that had been there before, and so she talked the guard into taking us on a driving tour.
All right, yeah,
So
I don't want to have a lot of new testimony. That's close enough. All right. So, and let's go to exhibit FR 25.
Right.
Sorry, Miss Mullen, bear with me. All right, and same thing. Did you take this picture, Miss Fry?
Yes.
And do you know approximately when, like to the year or something?
Same time, around 2015.
Oh,
Okay,
Mr.
and-
Lilly, quick question. Is this also FR 24? And what page is it?
This is FR 25.
25.
And what is this a picture of?
If you zoom in to the left, you can see the arrowhead on the mountain.
Yes,
Monument.
I do. See.
Do you see that? Mm-hmm. So that's Arrowhead Mountain.
Yeah. So what's the little pond in the foreground then?
That's one of the reservoirs on the property of Arrowhead Springs.
Okay, that's good enough. I just wanted to get some general location for these two pictures. Thank you.
Mm-hmm.
All right, so I'm not gonna belabor this. And with that, thank you, Ms. Fry, and Ms. Mull, you may take down that screen sharing. Thank you. So with that, I think we now have completed every party's presentation of their case in chief. Mr. Petroselli, your hand is up. Go off mute, though. There you go.
I'm sorry. I put my hand up to ask which exhibit that last photo came from, and I forgot to put my hand down.
Okay, we've got that on the record. Thank you. All right, so I believe now all parties who asked to present their cases in chief have presented their cases in chief. Have I missed anybody? Hope not. All right, so let me just talk about how we go forward from here. And I will come back then. We have two matters with requests for documents, which I will get to next. But we do have the site visit noticed for, I believe it's, make sure I have the right days. I believe it's February 16 and 17. And I still have not heard back from the San Manuel band. At some point, I either will or I won't. But then I will try to prepare a formal notice of the site visit, ask people if they're going to attend to let me know so we can make a list of everyone who's going to attend. I have the warning caveats about the dangers of going out there and our proposed schedule and itinerary. And Mr. Lowe, your hand is up. What is your question?
I was going to ask if, or just let you know that if the tribe doesn't give us permission to go down there, it's real important that we add the Red Rock Wall like I talked about before, because you can see basically the entire watershed from there. And so it would just, you drive right to it and there's lots of parking. And anyway, that's.
Okay. I'll tell you what, Mr. Lowe, and if you need to, I'm going to volunteer Ms. Doty to help you. Please prepare a map. I know you had one before, and if it's on the one you Ms. Doty previously submitted, that's fine. You recommended we go to a turnout where East Twin Creek crosses, I believe it's 40th, I'm going to say Street or Avenue, but I may be wrong. Is that what you're talking about here, or is this some other location?
No, this is up at the top of the watershed, right close to where you guys are going to walk into the 1, 2, 3, 4, 8, and where we're going to walk 7. It's right within a mile of there. It's a big turnout where everybody looks at to look at the watershed. So
okay. Yeah, I'm trying to wrap this up if I can. Please work with Ms. Doty to prepare a map that shows where that is and describes it, and send an email to the Administrative Hearings Office email address, and of course, send copies to everyone on the service list. And basically, your subject line can just say something like recommended stop for site visit or something like that. And if it makes sense, and it's where we're driving by anyway, we'll certainly stop there. Particularly, I like it when you say there's a large turnout so we can get off the highway and get out of traffic. That's important. And if we can do that and look around and can point things out, that's good. I want myself and my colleagues to see as much as we can about this. So we will do that. Thank you. All right. So then, assuming we can complete the site visit, and obviously that's weather permitting, then we will go forward. And our next date, we have a actually before the site visit, I believe there's a deadline. Let me just grab my supplemental notice here. I'm like Mr. Lowe, I have 20 piles of things out here. So the hearing notice does talk about rebuttal. Oh, Ms. Fry, you have a question. Go ahead.
I just wanted to tell you in FR 10, you can see Red Rock Wall on the map.
Okay.
It's right off Highway 18.
So
that
work
might be
with,
helpful.
That's good.
Okay.
Thank you. So work with Mr. Lowe and include that in the text of the email you're going to send to me with copies to everyone else that describes that. That would be very helpful. We've got it in the record, so you don't need to add another copy of it, but do cite it so we know where we're talking about. Thank you. All right. So rebuttal. The hearing notice does talk about rebuttal. I probably should read it, just so we're clear on this. Find it. There we go. This is on my November 17, 2021 notice of second pre-hearing conference and public hearing. On page 21, the second paragraph is lettered little c, and it reads rebuttal. And it's just a couple of sentences, so I'm going to read them here because it's really, really important that all of you follow these rules. Rebuttal. After all parties have presented their cases in chief and their witnesses have been cross-examined, and that's where we are now, the hearing officer will allow parties to present rebuttal evidence. Rebuttal evidence is new evidence used to rebut evidence another party has presented in its case in chief. And that's important. This is not another whole open slate to start over again. It really has to rebut. That means respond to, show what something's wrong or dispute or challenge something that someone else has already presented into evidence. The next paragraph of the hearing notice provision reads, all parties shall submit any written proposed rebuttal testimony and rebuttal exhibits by the deadline specified in this notice. And with a supplemental, the January 27 supplemental notice, that deadline is now February 14 at 1 p.m. Any written proposed, I'm reading from the notice again, any written proposed rebuttal testimony shall specify the previously submitted testimony that is being rebutted. And the best way, if you're referring to somebody's testimony, is to refer to their written proposed testimony. That's, if you need to, you can cite to the day, hour, minute, and second of the Zoom transcript, and that's, or the Zoom recording if you need to, but it's obviously just a lot simpler to cite to written testimony for if you want to rebuttal it. But this is very important, and what I want to try to avoid is back and forth arguments about whether or not something really is rebutting anything else and so forth. So that's why I have this requirement that the rebuttal has to specify what previously submitted testimony is being rebutted. And then the hearing notice goes on to state, cross-examination of witness offering rebuttal evidence normally will be limited to the scope of the rebuttal evidence. So we're not starting over. We do have to get done at some point with this hearing. So again, that's the deadline. You've all had the other parties' testimony since December 17th. And that's going to be the deadline for submitting rebuttal. I do obviously written proposed testimony and then other exhibits. If you can provide summary slides, that certainly helps summarize, as you've all learned. So that's my plan on that. So Ms. Taylor, your hand is up. Please go ahead.
Yes, Mr. Lilly, thank you. This brings up a concern that we have, and that I think Ms. Doty started to talk about briefly yesterday, which is that it appears that BlueTriton's made something of a strategic decision to hold back significant technical and potentially expert evidence for rebuttal only. They did this despite making the argument, technical argument in their motion to dismiss that all of the water at issue here is groundwater, not surface water. And despite the fact that they've been on notice since the ROI was released of all of the technical evidence supporting the prosecution team's case in chief. Initially, BlueTriton indicated that they would be putting on this type of technical evidence in their case in chief, and they even asked you for additional time to prepare their case in chief so that they could do that and respond to the prosecution team's exhibits adequately. And despite having the extra time and being on notice of everything that would come up in this proceeding, they chose to hold back significant technical evidence. It's clear that they have this evidence. This was confirmed at least in Mr. Donlan's recent letter to you, where he refused to produce coupled groundwater and surface water studies that the Center for Biological Diversity requested. And he even noted in that letter that at least one of the reasons why he wasn't going to produce it was so that they could hold it back for potential use in rebuttal.
Okay, I get all that. So what is your
Sure.
objection, comment, request, or something like that? What do you want me to do?
I think that it's important, and to protect our due process rights, and also just to save time and be more efficient, that the other interested parties and the prosecution team as well has an opportunity to present their rebuttal. Essentially, BlueTriton has withheld its evidence that should have been put forth in its case in chief that potentially is directly responsive to the request, to the ROI, and supportive of their arguments in their motion to dismiss. They've held it back just for rebuttal. That should have come in their case in chief.
Okay.
Without, go ahead.
I think I get your point, and I don't want to interrupt you too much, but let me say what I'm going to say, which I think will address your concerns. First of all, BlueTriton made a decision for what they submitted and what they, as you put it, held back. And they had a right to do that by, as you put it, holding back evidence. They did take the risk as to whether or not there would be evidence in other parties' cases in chief that they then could rebut. But it's almost inherent in the process that when there's a respondent, that a lot of their testimony may be responsive to in this case, the prosecution team's evidence and the evidence of other parties that support the prosecution team. So I'm not going to criticize BlueTriton for what they did, and I don't think it's appropriate for you to criticize them. They made a decision, and that, at least so far, complies with the rules. Of course, it does have to be rebuttal. It has to rebut something that another party has submitted. And in some ways, it may actually be cleaner this way, because if they had submitted evidence in their case in chief, at that point, all they had was the ROI and the draft cease and desist order, and they could have presumably responded to that, but then there'd be the additional prosecution team evidence and the other parties, I'll call it supporting or corroborating evidence. And in some ways, it's cleaner for BlueTriton to wait and rebut that all at once rather than doing it in pieces or piecemeal. So I don't have a problem with BlueTriton submitting rebuttal evidence. I presume they will be the primary party that will be submitting rebuttal evidence, because BlueTriton did not submit a lot of evidence the first round, so there's not a lot for other parties to rebut. There may be some, but not a lot. Now, getting to your other question or comment, I do completely agree that this may raise the need for surrebuttal. If BlueTriton submits significant or substantial technical evidence that other parties believe they need to respond to, then we may have to do surrebuttal. I don't want this process to go on and on and on and on, but I do want everyone to have a fair hearing. And if that means we have to go through a couple of different rounds, we will do that. So rest assured that if some party believes that submitting surrebuttal evidence is appropriate and that they have a right to do that, we will set up a process for that. I'm not going to close the hearing evidence prematurely before some party, to prevent some parties from submitting relevant evidence that can come in this sequencing I'm talking about. So I hope that addresses your concern. Ms. Taylor, do you have anything further you want to say on that?
No, that addresses your concern. And I'm certainly not trying to criticize or question their BlueTriton's ability to submit rebuttal evidence. I think we all have the due process right to do it. And what you've proposed for how to deal with a potential rebuttal addresses our concerns.
Okay, thank you. So Mr. Lowe, your hand is up. Do you have something else you'd like to say right now on this topic?
I'm sorry, I didn't put it down.
Okay, all right. All right, so that's the plan. February 14, 1 p.m. I'm sorry.
My virtual hand is up. This is Mr. Donlin.
Wait a second, where are you?
I don't know. I'm in the top left corner on my screen.
Oh, there you are. You now are there now that you're talking. Okay. Please go ahead, Mr. Don. I'm sorry. I think you're on page 2.
I just want to ensure that we will have the right to oppose any rebuttal. It's not in your hearing notice. The parties were all aware of the process. Your articulation of the reason we have withheld a testimony for rebuttal is absolutely correct. And in fact, all of the evidence that SOS and Mr. Lowe and Ms. Fry have put in that is new would not have been, we wouldn't have been able to rebut that had we put in all of our technical case, which of course we have no obligation to do until we see the case against us. So we just want to note for the record that we will oppose rebuttal if parties attempt to do that. It's beyond the scope of your hearing notice.
All right, and on that topic, Mr. Donlin, I'm going to read to you section 10 on page 19 of the November 17 Notice of Second Pre-Hearing Conference and Public Hearing. And that's titled Order of Proceeding. And it reads as follows. The hearing officer will follow the order of proceeding specified in California Code of Regulations, Title 23, Section 648.5, unless the hearing officer decides to modify the order of proceeding before or during the hearing. So I think the notice is pretty clear that the hearing officer has reserved the right, including modifying the order of proceeding, includes the right to allow rebuttal if appropriate. I'm just going to check the regulation here, make sure I haven't missed anything here. Okay, I don't see anything. It could be something in the regulations or not, but I believe that the hearing officer I have discretion to allow certain rebuttal evidence. Now, it does have to be rebuttal to what BlueTriton puts on, but I'll just say this is not a game. The goal here is for all parties to have an opportunity to present evidence that's relevant to the hearing issue. So if BlueTriton submits significant additional evidence and parties believe they need to respond or rebut that, I'm going to allow them to do that. So, Mr. Donlin, do you have anything else on this topic you'd like to say at this point?
No, let me take my hand down.
Okay. And we can talk about this more after the conclusion of the rebuttal phase of the hearing. And, and certainly, Mr. Donlin, if you believe there's some objection that's appropriate, you may raise it at that time. But I just want everyone to be on notice. That certainly is my plan, would be to allow certain rebuttal. So, Mr. Grady, your hand is up. Go ahead.
Ms. Grady.
Miss Grady, excuse me. Did I say, oh, Grady? I'm sorry if I did.
I'm a miss. But I just wanted to remind you.
I'm really sorry if I said that. Miss Grady, please go ahead.
Thank you. I just wanted to remind everyone that we do have transcripts from the court reporter available. The Zoom transcripts, as you noted, were not terribly reliable. So just wanted to remind that we do actually have a court reporter in this proceeding.
Okay, and what I said at the beginning, I'll repeat now. They're not part of the administrative record unless somebody submits them. If somebody submits them to my office, we are going to post them on the administrative record where they're available to everyone. So, I know there may be issues with the court reporter wanting to get paid for copies of the transcripts and so forth. But Ms. Grady, do you plan to submit those transcripts to the AHO to have them be added to the record?
I'm not sure at this point, but for purposes of reaching out, I just wanted to remind everybody there is a court reporter here and they can certainly contact her.
Okay, and that's certainly, they can either coordinate with you or the court reporter if anyone wants to get a transcript. But as I've said, my view is the Zoom recording video plus audio is the official record of this proceeding. The Zoom generated transcripts are just helpful, but they, as you've just pointed out, they're not 100% accurate. It's just a computer trying to turn voice into words. So they can be useful for people finding the specific times when things are discussed, but they are not the official record. So anything else on that? Okay, and Ms. Grady, if I said Mr. Grady, I really apologize. It's late in the afternoon, but that is not excusable, and I apologize for that. Okay, so I have two other things I wanted to talk about today, and then we'll move forward. The first is for Ms. Belenke. Ms. Belenke sent me an email with copies to the other parties on January 24th, which referred to Mr. Lawrence's testimony on direct about a coupled groundwater and surface water model, which had been prepared as part of the adaptive management plan in the process that BlueTriton was involved with the Forest Service special use permit application. And she asked that, I think, and Ms. Belenke, correct me if I'm wrong, but I think you asked that I direct BlueTriton to produce that information because other parties may want to, it says here, produce as soon as possible to determine if rebuttal testimony is needed. I asked Mr. Donlin to respond to that request, and he did with a letter dated January 28th, which he sent to me and served on the other parties. And it goes through has several different points on why he believes that the hearing officer should not order BlueTriton to produce that coupled groundwater and surface water modeling information. So, Ms. Belenke, do you have any response that you'd like to make today to Mr. Donlin's letter?
Yes. I do have response. the document was raised on examination. It wasn't actually mentioned specifically in the testimony. It is relevant to the issues in this hearing, and it is readily available to BlueTriton. Certainly, it appears that the document could be subpoenaed, and you asked that you request it in hopes that that would save time. So that was my purpose. As far as not seeking it during the cross-examination phase, I quite frankly was going through all the documents again to make sure we didn't already have it, and I could not find it. And then by the time I had time to do that, the cross-examination phase was over. So I apologize for that. I think those were my main points. It is a relevant document and it could be subpoenaed. And my understanding of the rule is that we can actually ask you to subpoena documents or subpoena them ourselves as attorneys who are representing parties.
Yes, and that is correct. So here is what I'm going to do. First of all Mr. Lawrence did was say he referred to the fact that this modeling had been done and was submitted to the Forest Service. I don't think he testified at all regarding any of the content of the modeling or the results or anything like that. And, my guess, not knowing, I've not seen any of that, but coupled groundwater surface water modeling sounds pretty complicated to me. So I think there probably is a significant amount of technical information there. It may or may not be relevant to this hearing. There probably are hundreds, if not thousands, of documents out there in the world that may or may not be relevant to this hearing. I am not going to order BlueTriton to produce that document. I don't think there was enough testimony by Mr. Lawrence to really raise questions regarding that. I mean, it's intriguing. It may be interesting, or it may set us down a path of another week of hearing proceedings and turn out not to be useful. So anyway, long way of saying, I am going to deny your request that I direct BlueTriton to produce that documents. And I'm not even sure what documents it is. I suspect it's probably a whole set of documents. Modeling usually involves a lot. This is probably no exception. There may be model files and so forth. Now, as you said, Ms. Belenke, you do have a right as an attorney representing one of the parties in this proceeding to prepare a subpoena and serve it on BlueTriton. And of course, BlueTriton has a right to file a motion to quash if they do not think they should have to produce that. So I'm going to leave it to you to decide if you want to pursue that. And if so, that will be up to you. And if you do, then there will be a question as to whether it's going to be appropriate for a rebuttal phase and so forth. And as you probably know, I'm sure you're an experienced attorney, and I know Mr. Donlin is, and both have done civil litigation. For any discovery matter, if the parties can try to meet and confer, always is the statutory language, see if you can work things out and reach an agreement on that. So please try either before or after you serve the subpoena, because if you can work it out, that's going to be the most efficient. And if you can't, and you decide to serve a subpoena, and Mr. Donlin or one of his colleagues decides to serve a motion to quash, then I'll probably ask for further briefing, and then when I have time, I'll issue a ruling on that. But that's the way I'm going to proceed on that. I'm not going to order BlueTriton to produce that now.
Thank you.
All right. The other matter I have also concerns a production of documents, and this is a letter I sent to Mr. Donlin on January 26th, which was following up on Mr. Lawrence's testimony during the first week of the hearing. And I asked for three kinds of three sets of flow data. The first one was the monthly amounts of BlueTriton's deliveries to the San Manuel Band or predecessor owner of that property, which my understanding is may go back fairly far. I don't know how far the records go back. The deliveries apparently go back fairly far in time. And then records of the daily amounts of discharges from the discharge facility near boreholes 10, 11, and 12 to Strawberry Creek for all days for which such records exist. And my understanding from Mr. Lawrence's testimony that those discharges did not begin until some date in 2020. So it's days, but it's over less than a 2 year, probably less than a 2 year or approximately a 2 year period at most. And then the third one was the amount of discharges from the holding tanks described in Mr. Lawrence's testimony, or the other, and that's down near the old hotel area where there apparently used to be discharges into the creek. And I don't even know if those were metered, but if they were, I was asking for the amounts of those discharges. Those were the three types of flow data that I asked for. And then I also asked for a schematic diagram of the present configuration of the tunnels and boreholes, the pipes, holding tanks, and discharge facilities, and the valves and meters associated with those. And during the testimony, Mr. Lawrence said that he thought he could prepare such a schematic. And frankly, I just thought it would help all of us to make sure we're accurately describing where the waters flow and what these different facilities are. So that was my request. I received a letter from Mr. Donlin dated January 30th, and again, also served on everyone on the service list, objecting to that request on the grounds that it was unduly burdensome and that it improperly placed the hearing officer in an investigative role, and that there was no legal basis for the hearing officer to compel production of that submittal of testimony and exhibits. So first of all, regarding the unduly burdensome argument, Mr. Donlin, I am surprised by this. I thought that this type of data is the sort of thing that BlueTriton and its predecessors would have in readily available form, either electronically or in paper, and it was simply a case of compiling that. So if you want to say something about that, that's fine. If you want Mr. Lawrence to explain why it's unduly burdensome, that's fine as well. But I'd like to understand why you contend it's unduly burdensome.
Well, I think Mr. Lawrence's, I'm sorry. I think Mr. Lawrence's testimony, Mr. Lilly explained how this data is kept. And it's run off of solar panels, and it's not reliable. It takes a while to synthesize it, to correlate it, and then to do quality control. And you're asking us to put this into an adjudicative proceeding before it has been put through those processes. I talked with Mr. Lawrence and asked him how long it would take to compile this data as you requested it. And he told me dozens of hours, as I reported to you in my letter on Sunday. So I think the letter speaks for itself and is responsive. I don't know if you want me to just stop there on that issue in our response, but you were asking for a lot of work for us to pull that together.
So when you talk about the solar panels, I assume that's the meter that on the discharge from near boreholes 10, 11, and 12 into Strawberry Creek. Is that correct?
Mr. Lilly, I'm not an expert on the configuration of the system. Again, I asked Mr. Lilly or Mr. Lawrence to help me understand what would be involved in responding to the request. He looked at it closely, and that was the answer that we got back. Keep in mind that we are in the process and for preparing for this proceeding and have been here all week. You asked for the data by tomorrow, and it wasn't feasible.
Well, if you need more time, that's a different question than whether or not you're going to respond at all.
Well, that was one of the grounds that we reported to you.
All right. So, Mr. Lawrence, there are three different kinds of data here, and I'm hearing perhaps different perhaps different levels of burden with each type of data. So please tell me regarding the first ones, the monthly deliveries of water to the San Manuel Band and its predecessor, basically at the Arrowhead Springs Hotel property. First of all, can you tell me what years that data covers and what format it is in?
So, Mr. Lilly, the format has changed. I mean, many years are paper copies that I have to request from the hotel owners. We don't have a long record of the paper copies. They keep those. And then more recent years, we do have electronic information. Some of that is readily available, but not all of it. And it has not been through any kind of quality control at this point, at least the most current data.
When you say most recent years, what are the years for which electronic data is available?
2000, I believe it's 2001, 2021, 2022.
Oh,
Sorry,
okay.
sorry, 2021.
Try again.
2000, yeah, sorry, 2020 and 2021, as well as the beginning of 22.
Okay, so those are the only years where electronic data is available.
I believe that's correct.
And just so you know, Mr. Lowe, I do see your hand up. I want to cover this before I come to you. And then for the discharges near boreholes 10, 11, and 12, you did explain that, but can you just elaborate a little bit on what's the format of that data?
Certainly. So, and if you don't mind, I'll just cover kind of the general arrangement. It's the same at each of the collection points. So the solar panel powers a set of batteries. The batteries provide power to metering and our security system. The metering is turned on and off on a frequency to collect the data. We can't leave it on continuously because it will drain the batteries and the solar panel can't keep up. These are pretty small systems. And so I don't know off the top of my head what the frequency is right now or over the years, but it's generally going to be multiple times during a day that we'll collect flow data. Then that data is synthesized into an average for the day. Those totals are combined and then synthesized into monthly data and then annual data. That process has to go through quality control. Sometimes, prior to the newest forms of meters that we have in place now, the magnetic resonance meters, we had meters that were propeller driven, and we would get debris in those at times and have to go back and recalibrate those meters, and then also look at the data over a period of time when the meter was malfunctioning.
And I maybe I wasn't clear, Mr. Lawrence, but I was not talking about the meters that measure the flows from boreholes 10, 11, 12. I was talking about the meter that measures the discharge from that complex into the creek in that location. So does that change your answer?
Yeah, my apologies. That meter is a mag meter. It's been in for a short period of time. I'd have to go back and look. It's months, not years. We might have had it operational for a year now. I'm not positive that's the case, but I'll have to go back and look at that data. And if that's the only data that you're looking for, does reduce the burden significantly, but we still would want to do qualitative work on that to make sure it's accurate data. Okay.
Yeah, so I'm glad we got that clarified. And then the last one was I'll call it the old discharge area, which I think you testified was down near the holding tanks, or somewhere near there into East Twin Creek. I think it's what it is at that point. Or is it still Strawberry Creek at that point?
Yeah.
Which one is it?
It actually flows to the surface and then down into Indian Creek, then into Twin Creek, East Twin Creek.
Okay, and was there ever any meter on that discharge?
There's not meters. There are no meters on the tank overflow.
And so that's what the discharge is the tank overflow?
That's correct.
Okay, well, that makes it fairly simple. If you don't have any data, I'm not going to ask for it.
Okay.
So, all right. So here's what I'm going to do on those matters. The deliveries to San Manuel Band, it does sound like there's a fairly clear cutoff between electronic meter data that BlueTriton still has and paper data that only the tribe or its predecessors have. And then the discharge, it sounds like that's, again, it's a fairly limited time frame, but you're going to check into the mag meter. So I'm going to reserve a follow-up ruling on that. We have to also cover Mr. Donald's other points in this letter until after the site visit. I'll probably have a better lay of the land. I know I'll have a better understanding of the lay of the land after that, and that may help. So then the last question of burden was, and I'll just ask you, Mr. Lawrence, this schematic diagram, I thought we had a fairly clear discussion of that, but please tell me what sort of burden is involved with preparing that. And I understand that would be a new document, but what kind of burden is involved with that?
I think we can manage to put together a schematic diagram in a reasonable amount of time. I would like a little more than tomorrow, of course, but if I could get a couple of weeks, that would be nice. That would be plenty of time to do that.
Okay, well, that certainly is understandable. All right, so thank you, Mr. Lawrence.
My pleasure.
And I'm going to shift back to you, Mr. Donald. Your next argument was that basically it puts the hearing officer in an investigative role in this proceeding. That's what the heading is. And I guess I'll say I understand what your argument is, but I don't think I agree with it. I think when there are hearing issues and there's evidence, I think it's appropriate for the hearing officer to ask for some supplements just to have a full understanding of the evidence. I mean, this is not conducting an investigation. It's just basically adding some evidence to the hearing record so the hearing record is clearer for us to be able to prepare a proposed order. So do you have anything further you want to say on that?
Yes, Mr. Lilly, thank you. I think this goes back to the broader issue that we've discussed several times, and that is the scope of this proceeding. We requested a hearing again on the April 23rd, 2021 draft cease and desist order put together by the State Water Board's Division of Water Rights Enforcement Team. That's what we requested a hearing on. The enforcement team and the prosecution team have never requested a lot of the information that you've sought from witnesses, including in this information request, which to us imputes that you are applying some sort of relevancy standard to information to inform a case against us. The case that we requested a hearing on is the prosecution's case. We do not believe it's appropriate, and it intrudes into the investigative role of the State Water Board for the hearing officer to start asking for information that goes beyond the charging document. And that's in the Administrative Procedures Act, not in your hearing notice or State Water Board regulations. So the fact that you are asking for this information to be produced is implying that you think it's relevant when the State Water Board prosecution unit did not.
Okay, and Mr. Donald and Ms. Fry, I do see your hand. I will get to you. Bear with me. When you refer to the Administrative Procedure Act, Mr. Donald, are you referring to the two government code sections that are cited in your letter?
Yes, the Administrative Procedures Act Bill of Rights, and also the reference therein to, I believe it's, yes, it's the citations in my letter.
Okay, your letter cites government code sections 11425A4 and 11425.30. So I will take a look at those.
That is correct. Thank you.
All right, and then the third deferred argument you made on this topic is there's no legal basis for the hearing officer to compel production, preparation, and submittal of testimony and exhibits. And that one I don't really understand, because I think that the statutes applicable statutes and the board regulations state that the board on its own motion may prepare and issue a subpoena. So, I mean, I thought we could just do this with a request from me, but now I do agree that the schematic, since that's not an existing document, if we wanted to get really technical, that's probably not subject to a subpoena. Although I sure think it would be helpful for all of us, including mainly me, and Mr. Lawrence certainly indicated that's not a significant burden, at least with more time. But for all of the data that we're talking about, aren't those all subject to subpoena anyway?
Well, one, I'm not sure. This is a private entity, not a public agency. The jurisdiction of the State Water Board in this matter has not been established. And in fact, that's the issue in this case. So I think there is an open question about whether the raw data is subject to a subpoena. But beyond that, you're asking for the data to be compiled and synthesized. And that I'm not sure is subject to subpoena and requires preparation of work product.
Well, and that certainly is a dilemma, because I don't think you want to give us the raw data that probably is subject to subpoena if you think the quality control needs to be done. And I certainly have worked in this field long enough to know the need for quality control on flow data. I mean, it's just the way it is. It comes out and it needs to be gone through quality control and so forth. So, all right. Well, I guess I appreciate your answer on that. I don't think subpoenas are limited to public agencies. I think they're appropriate for parties to proceedings. So I don't think I agree with you on that part of that. But anyway, first of all, I will stay any requirement for compliance by the February 3rd deadline. I think both of you, Mr. Lawrence and Mr. Donlan, have raised some legitimate concerns about the timing of that. And I'll review this and decide when, how I'm going to rule and what an appropriate time is if I am still going to request this information. So, Ms. Fry, your hand is up. Would you like to address this issue?
Yes, I'm addressing Mr. Donlan's comments about undue burden. As a public member, and all public members that have given hours to this case, I find his comments offensive.
Okay, well,
they're paid, I'm
not,
unpaid. I just want to make that known. And the water is in the state of California. It is for the benefit of the people of California. Thank you.
Okay. Let's, first of all, Ms. Fry, I'll just say, I mean, I'm not sure I agree with your testimony. I'm not prejudging it, but I appreciate all the hours you spent on this. I know you were dedicated to trying to find information that you thought was relevant, and you have told me you were not paid. And I do appreciate this effort. As I've told you before, the State Water Board, my bosses, certainly encouraged interested members of the public to participate in the board proceedings, even if they don't have attorneys representing them. But I don't want to get into arguments of burden. I mean, let's face it, a hearing like this is very burdensome on everybody. It's just the nature of the process. We require detailed evidence and preparation. The more preparation, the better. And it's burdensome. So I hear that. I think Mr. Donlan is correct. This has been burdensome on BlueTriton. You can argue that's the price they pay for doing business, and it's burdensome on everyone else. So I don't really want to spend a lot more time on that. I'm trying to make the proceeding as efficient as I can, but they're going to be burdens to get all the information out. So with that, Ms. Doty, do you have something you want to add?
I do have something to add that might be helpful. The March 19, 2019 Adaptive Management Plan that BlueTriton brand's predecessor entered into with the Forest Service requires certain monitoring of flow. And that has to be reported to the Forest Service. So I believe some information that's at least similar to what you're seeking may exist. We've attempted to get that through FOIA requests, but have been unable to. So that is a possibility, and I'd be happy to send you that adaptive management plan if you'd like to review it.
All right. I don't think I need to see that. I don't know that I want to go down that path. I think it's up to you to pursue what avenues you can as an attorney for one of the parties to obtain what documents you can. Of course, the board does have, authorizes parties to issue subpoenas if necessary, and we can go down that path. I think everyone needs to remember, though, we now are done with cases in chief, and we're talking about rebuttal. So it's got to be evidence that fits within the scope of rebuttal, except for these requests I have made, which I think are to explain Mr. Lawrence's testimony. So I'm going to take this under submission. I don't know when I'll issue a ruling on this. It might be before, it might be after the site visit. I do appreciate Mr. Donlin and Mr. Lawrence's comments about the burden and want to make sure that we do this in a way that recognizes that burden and yet gets information that I think is appropriate for the hearing. And Mr. Donlin, just so we're clear, I do disagree with you that this is part of an investigation. I think this is part of a normal hearing process. So with that, your hand is up. Is there something more you want to say today about this?
Well, I just want to make sure that we cover a few additional issues that we raised in our letter before we break. I don't know if you're reserving time for additional issues, but I want to make sure that we get that on the record.
I did notice in your letter, you referred to BTB's renewed motion to dismiss or for non-suit. Is that what you're referring to now?
In part, Mr. Lilly, yes.
All right, and I was confused by that because I am not aware of any renewed motion to dismiss or for non-suit. What are you referring to with that?
I'm referring to the motion that you invited in your, I believe it's the November 7th ruling, denying our motion to dismiss and inviting us to file the same or similar motion during the course of this hearing. Now that the case in chief testimony has been submitted, we intend to accept that invitation and file either a restated motion to dismiss or a motion for a non-suit. We intend to concurrently provide rebuttal testimony, and we think that will be extremely useful to you. And we intend to submit that by, I believe, February 14th. But on a parallel track, we would like for you to establish a hearing schedule for a motion to dismiss, which we are providing notice of today. And we are prepared to refile papers if that's what you request, or just a declaration that incorporates the evidence that the prosecution team and other parties have submitted in this case already that support our motion to dismiss.
Okay, so just to clarify, I went back and read my ruling, and I don't think there was anything in there I would characterize as inviting a renewed motion to dismiss. My ruling stated that the denial was without prejudice to BlueTriton's right to file a new motion if BlueTriton believed that was appropriate, but I don't think that's the same as an invitation. So I just want to clarify that. But in any event, if you, on behalf of BlueTriton, want to file, I'm going to call it a new motion to dismiss. I think that's better than to say refile. And you think there are new arguments that you want to make now based on the fact that we have had several days of hearing and the evidence has come in. And if that leads you to believe that there is some new basis for a motion to dismiss, then you may file it. I suggest you file it in writing. And most likely, I will set up a briefing schedule for the prosecution team and other interested parties as they want to file responses and potentially for you to file a reply brief as well. It's going to be a lot easier to have all that in writing, I think, than to try to do it any other way. But I'll say, advise you, you've got to explain what's new from what I ruled before. And, maybe you can, based on all the new evidence that's come in, but if you just rehash the same arguments that you made before, you're probably going to get the same ruling. So if there's something new, then I will consider that and proceed accordingly. So anyway, that's just that admonishment to you. And with that,
I appreciate that. And I guess I would ask you to clarify what you mean by that. You denied it on the grounds that you wanted to receive, and you thought it would be beneficial to receive technical information. But again, it's still the state's burden to establish that there's adequate grounds for a cease and desist order. And they haven't changed this testimony that was in the draft cease and desist order and the report of investigation. We're happy to submit that testimony. There's a few exhibits that they did submit that bolster our case, and we will submit that as well. But I didn't read you reaching the merits of our motion previously. You said you were exercising your discretion until such time that additional information was put into the hearing record.
all right. So now that we've had everyone's cases in chief, if you believe that I should issue a different ruling, please go ahead and state that in your motion. You're right. It's times are different now. We've had however many, approximately 10 days of hearing with voluminous evidence that's come in. And if you think that puts your prior motion now in a new context, then state the new motion in that context. And just so we're clear, I think this is obvious. You said you could submit a lot of exhibits. If exhibits are already in the record, you don't need to submit them. You can just cite them.
We will cite to them, Mr. Lilly.
Yeah, I figured that's what you meant, and please do. And then we will review it. I suspect Mr. Petrozelli will want to file a response, and then we'll go forward. So Mr. Petrozelli, your hand is up now. Go ahead.
Mr. Lilly, I'm having a hard time, especially in part with the timing. We're submitting rebuttal testimony in less than 2 weeks, and we will be having rebuttal. And then after that, closing briefing. So, as far as briefing on, these legal issues that would likely come up in BlueTriton's renewed motion to dismiss, we're pretty much there with the closing briefing. So, given the timing, I have a hard time seeing the point in a motion to dismiss now when, when we'll be briefing the same issues right around the corner. It's coming up fast.
All right. Well, I think BlueTriton has a right to file the motion. And if you want to make those arguments in your response or your opposition, I assume it will be an opposition from what you just said, then please go ahead and make those arguments. Just so we are clear, I am not going to change the current hearing schedule for submittal. And I didn't hear Mr. Donlan to ask me to do that, but I'm not going to, and I'm not going to. The deadline for written proposed testimony on rebuttal and rebuttal exhibits is still February 14, and the hearing is going to start on February 28. Depending on when Mr. Donlan files the motion and what time I give for you to file your opposition, and he'll probably want to file a reply. And then, of course, I have to prepare a ruling on that. We may or may not get to that before February 28th. So we may proceed with the rebuttal hearing, and then there'll be a ruling on that. But I think since Mr. Donlan, he said invited, which I don't think I said, but I did say denial without prejudice. So he does have a right to file the motion. You'll have a right to file opposition, and we'll go forward. That's what due process is all about. So anything else on that topic for today? And I don't know, Mr. Donnelly, I'm not going to hold you to it because you're not required to do it at all, but do you have an estimated time frame for when you may be filing what I'm going to call a new motion to dismiss or for non-suit?
I don't have a specific date, Mr. Lilly, but we do expect to maintain the schedule for rebuttal testimony and the rebuttal hearing. As I said, we are expecting that the motion to dismiss or motion for non-suit would be a parallel process to the hearing as you've scheduled it. So I would expect that we should file our motion by February 14th.
Okay. All right, and again, I'm not holding it to, I'm not going to set a deadline for a motion that's totally up to your discretion as to whether or not to file at all. But if that's good to know that that's your target timeframe. So I mean, it's just good for us to know. So, oh, Mr. Petroselli's hand was up, but it's no longer up. You're now up. You want to say something?
I was going to ask that, that you give BlueTriton a deadline for filing such a motion, because then again, we just run into closing briefing.
Well, I thought about that, but it may very well be that BlueTriton decides they want to file a motion to dismiss or non-suit after the rebuttal evidence has come in, or potentially after SIR rebuttal has come in. So that's why I'm hesitant to specify a deadline for that. To some extent, this hearing's a moving target, and I think BlueTriton should have the right to decide how they, basically, if they want to file a motion, and if so, when. So I'm not going to set a deadline for that. But I will set a briefing schedule once they file the motion. So that's my judgment call for the best way to handle that. So that's what I'm going to do. All right. Mr. Donnelly, you said you had something else. I don't have anything else on my papers. Is there something else on your list?
Yes, Mr. Lilly, and we've raised this in the past. We respectfully request that you reconsider the date of the site visit, and here is why. We think it would be very beneficial to you to have rebuttal testimony before you go out in the field. I respectfully request all of the time and effort that Mr. Lowe and Ms. Fry put into their testimony and SOS, but you've heard one side of the story, and we think that our rebuttal testimony will be very helpful to your understanding of the watershed, and we encourage you to take that rebuttal testimony before you go out into the field. We think it will lead to a much more informed site visit for the hearing officer.
Okay, well, that's an interesting point, and it's a judgment call. And I'll tell you what my response to that is. I'm going to deny that request. It's been so hard to schedule the site visit that I want to get out there. And again, it was BlueTriton's decision not to submit any more evidence than it did in its case in chief. As I said before that evidence came in, when we had our first pre-hearing conference back, I think it was November, I really want to have additional hearing days after the site visit so that if I have questions, and I don't even know which witness it would be for, it could be for anybody who explains something about the site visit, that I can ask those on the record. I mean, it doesn't work well to have formal testimony out in the field. The logistics just don't work well. I think everyone can appreciate that. So I want to have it before our next round of hearings. Number one, I just want to be able to understand the physical setting. And also, I am a little concerned. We start getting into the hotter weather, and Mr. Lawrence said there was a problem. I know they were out in June before. There was a problem with rattlesnakes, and none of us want to have that kind of encounter, obviously. So I'm going to stick to February. I think whatever the dates were, I think it's 16 and 17, unless there's a weather reason we can't go then. But having said that, Mr. Donlin, as part of your rebuttal, and if necessary, you can bring it up during the rebuttal hearing. If you think we need to go out there again after the rebuttal evidence has come in and basically say, put it colloquially, you need to go out there again to look at this because this was raised during rebuttal. And I think now it's important that you see that. I will consider that. It's not that hard for us to fly from Sacramento to Ontario and to rent a car and go out there and see that. So I will leave that open. We'll have to be careful about snakes if we get into May and June, obviously, but we will do that if we need to. So I guess I'd say I think that's the way I'm going to respond to your request. I'm not going to postpone the current site visit, but I'll leave it open if we have to go out there again. We can do it with some logistical challenge, but we can do that. And of course, we might not need to go see all the sites, but I'll do that. Frankly, if we haven't heard from the San Manuel band, that might be a reason to go down again as well. So that's how I'm going to handle that.
Well, thank you, Mr. Lilly. I respectfully request that you reconsider that. I do not believe it's an efficient use of the state's resources to go down there twice, perhaps not even once, particularly if the state has no jurisdiction over these water sources. We want you to see the site, trust us, and we want to do that promptly. But we don't think it's appropriate for you to go down there with a record that you've received thus far, which we feel is inadequate. We elected to put on our rebuttal testimony because we didn't know what the case against us was on December 17th. You yourself agreed with our reasoning for doing that. You stated it very well in response to Ms. Taylor.
Just so we're clear, I don't think I necessarily agreed with you. I explained how it worked and that you had a right to do it that way. But I think that's different from saying I agree. It was a strategy decision you made. I said you had a right to make that strategy decision. I'm not saying it was the right one or the only one. So I do want to be clear on that and make sure you're not putting words into my mouth on that.
I'm certainly not intending to put words in your mouth, but I think you said more than it was our right. I think you expressed some understanding of the reason why we would do that. That aside, I also need to alert you that there are some concerns with my client about the expanding scope of this site visit. And I do want to state now early that we've talked about indemnification and waivers in the past. We haven't heard anything from you about that, but there's some work that needs to be done before my client will let me and my colleagues participate in a site visit with the potential exposure to liability. And we put that in our letter to you, I believe on January 30th. So I just want to put you on notice that those are some issues that we need to work through on our end.
And are your concerns about indemnification, well, I'll just say about liability, do those relate to the helicopter portion or to other portions as well?
Other portions as well.
All right, I guess I'll say, well, first of all, let me say that the site visit notice, when I can finally get to it, which I hopefully will be able to soon now that we're done with this round of the hearings, it's going to state the warnings about the hazardous conditions. And there certainly are hazardous conditions, and I want to make sure everyone is warned about those. I have checked with the people at the State Water Board who are involved in things like this and have not received any information indicating that the state needs any waiver or indemnification for people to participate in the site visit. I mean, this is basically people walking on public lands, at least for the first day. And then if we're allowed to go to the tribe will discuss or let us know what waiver and indemnification requirements they may have. And if BlueTriton has waiver or indemnification requirements for people to travel in the helicopters that it is going to I'll say rent or charter for this proceeding, please let me know. And I think if there is such a requirement, we'll review that. But I did say before, I think any party to this proceeding has a right to participate in that part of the site visit. But if BlueTriton has reasonable waiver and indemnification requirements for the helicopter portion, we will look at that, and that may very well be appropriate to require people to sign that to participate in that. I will say, and you know, as lawyers, we try to anticipate issues and problems. I'm not sure how I see potential liability to BlueTriton for this part of the site visit that involves us walking from the rim of the World Highway down to the spring sites, which is all on federal property under a site visit that has been prepared, and basically set up by the State Water Board. So I don't get that part. I certainly do get the helicopter part. So is there anything further you want to say on that?
Well, I again, if there is an injury, and there will be with the group that you're talking about, some level of injury. Hopefully, there's no serious injuries. But if there's an injury, I think it's reasonable to assume that there's some exposure to liability that BTB has. Whether it's on federal land or not, you're visiting facilities that are controlled by BlueTriton, a private party, and you have folks that are participating in this hearing that could get hurt. I am telling you what our limitations are. You can do with that what you want, but there may be some limitations on BlueTriton and its team's ability to participate without some liability protections.
Okay, well, and certainly if BlueTriton doesn't want to participate in part of the site visit, they don't have to. As I say, I don't, of course, as we lawyers know, a lawyer can sue anybody for anything. So I won't say people can't sue, but anybody who's on this call today could go to Rim of the World Highway and go walk down to those sites right now, as I understand it. It's federal property and there's no federal exclusion. So I'm not seeing that it's a whole lot of a different story if we all happen to be walking down there on a certain date at a certain time. But why don't you, if you think there are legitimate concerns, I think the best thing is for you to put those in writing and send them to me, and not just stating what your concerns are, but stating what BlueTriton wants to do to address them. And then we will decide how to go forward on that. So with that, Ms. Fry, your hand is up. Go ahead.
I just want to say I've been there many times and I've gone with many parties and journalists all over the world, and nobody's ever been hurt. So
good.
We've never had a problem. So
well, I hope we can keep it that way. But
me too.
Mr. Donlan is right. He was not right when he said there will be injuries. I don't think I would agree with that. But to say that there are risks, I think he certainly is right about that. I mean, this is rough terrain, and people hiking on rough terrain, there could be injuries. That's absolutely something that could happen. So, Mr. Bilecki, your hand is up. Please go ahead.
Thank you, Mr. Lilly. I'd like to echo Amanda Fry's comments moments ago. I've been on the National Forest in this area many times with individuals from 20 years old into their 70s, and no one has ever become hurt. I don't want to minimize the terrain, but we're not climbing Mount Everest.
Good. Well, thank you, Mr. Bilecki. And it doesn't look like we're going to get any rain, which is unfortunate. But if we get rain and the soil becomes slippery and there's some issue with that, then we may have to postpone for that. I mean, I don't want anybody to get hurt. I don't want to get hurt myself, and I don't want anyone else to get hurt. But on the other hand, as I said, when we had it seems like November was about 3 years ago, but when we had our conference call on the site visit, I explained to all of you that my colleagues, Mr. Anderson, Mr. Woldridge, and I, it's been our experience, and this is also my experience from my prior work, that going out and seeing a site is just invaluable for getting the lay of the land. I mean, I don't know what I'm going to see that I don't have in my mind or in the record now, because I haven't seen it. But my firm belief is you can get a lot of information from topo maps, aerial photos and people's descriptions, but there's no substitute for seeing something in real life, particularly when it's water facilities and mainly 3 dimensions, which just cannot be depicted on any map or aerial photo. So that's why I'm doing this. And we will all be careful. If anyone's concerned about the risk, no one's required to go on this trip, and we will go forward. I certainly appreciate that there are risks, but I think the value to me for this decision-making process outweighs the potential risks. So that's what I want to do, and that's how I'm going to go forward. So, Mr. Lawrence, your hand is up. Please go ahead.
Yes, sir, Mr. Lilly. I just wanted to reiterate that for the portion that requires helicopter taxi service, we will need some information from everybody and a list of participants to provide to that service. I'm happy to send to the copy list the company that we will use for that, so that that information can be sent directly to them.
Okay, I'd rather not do that. I'd rather,
Okay.
Mr. Lawrence, and I do appreciate your constructive attitude here, which I appreciate greatly. But send an email to the AHO email box, and if you want to, Mr. Donlin can send it, of course, and copy the service list and describe what specific information you need each person to provide. This always gets to be interesting when the pilots say they have to know how much everybody weighs, but which some of us are more willing to disclose than others. But anyway, if we have to do that for legitimate purposes, we will do that. And whatever other information, legitimate information they need, just let me know as soon as you can. And that's going to be a condition if people want to go on that part of the trip, is that they have to provide that information, because I certainly respect the logistical requirements. And
I appreciate that.
And we'll leave it at that. We'll see how many people sign up, and we'll go from there.
Okay, and
it's going to be 3 people from my office, including me.
Okay, and one of the requests I did speak with the helicopter service, air taxi service, and one of the requests is to make this efficient and to move people in a relatively short period of time. We'll likely use 2 helicopters, so we'll be coordinating with 2 helicopters, and they will provide folks on site at the 10, 11, 12 landing area for assistance in loading and unloading, make sure everybody is safe, and then we'll also do the same at the helicopter location at the San Bernardino Airport. And then we will likely want to form into groups. And what I'd like to do ahead of time is form groups that I can share with the helicopter service. So when they're checking people in and out of the helicopter, we have a group, and one helicopter will carry 4 passengers at a time, and the other will carry 3 passengers at a time.
Okay. So again, thank you very much for providing this, and just send me, no more information than you have to have, but whatever is legitimately required, send me the list of the information you need. And I certainly am more than happy to have that be a condition to anybody riding on the helicopters, that they provide any legitimate information.
Absolutely, will do. Thank you very much.
Including their weights. I just say
we'll leave that out for now, but yeah,
no,
probably going to be in there.
And in my experience in small aircraft, they often do want to know people's weights. So that's
weights of you with your backpack, for sure.
Right. That too. All right, Mr. Bilecki, your hand is up. Go ahead.
Yes, thank you, Mr. Lilly, and thank you, Mr. Lawrence, for providing a little bit more information on the helicopter portion, because my imagination would be that the hike from Rim of the World probably or may involve more people than on the helicopter, but that may be the same number. So I guess since it's just been discussed that there's 7 people, 7 passengers essentially between these 2 helicopters, is there going to be some restriction possibly on the number of people involved in the helicopter ferrying or not?
All right, and Mr. Bilecki, we addressed this before. What I said was every party, and the parties are the people, the entities and people who've submitted evidence for this hearing, will be entitled to have at least 1 representative on the helicopter. I'm going to get a list. If we have some party, it wouldn't be you individually, but if one of the I'll say entities that's appeared in this hearing wants to bring 6 or 7 people, I'm probably going to say no, because Mr. Lawrence is going to go through the roof with how much that would cost for extra trips. So at least 1 person for each party, For the prosecution team, I'm sure it'll be more than one, but it may not be everybody the prosecution team wants to bring. So those are my criteria. And again, we're having to grapple with logistics here, and I certainly appreciate BlueTriton's cooperative spirit in this. But I am very sensitive to ex parte communications and want to avoid those. And as I say, the State Water Board has a strong view on public participation. So parties that are participating in this hearing, I think, should be able to go. Now, having said that, if somebody just shows up and says, hey, I want to go for a ride too, the answer is no. And, particularly newspaper reporters, not to have anything against reporters, but they haven't participated in this hearing. So I'm not going to ask BlueTriton to accommodate those requests. Within reason, they can come on the hiking part of the trip, but not on the helicopter part. So I hope that answers everybody's questions on this.
Thank you.
All right. Any other questions? And I don't know if we have anything else to cover today. Do we have anything else to cover today? I think we've gone through my list. All right. So hearing nothing else, I guess we will look for rebuttal exhibits and testimony to be uploaded to our FTP folder on February 14th. Hopefully it won't interfere with all your celebrations of Valentine's Day. And then we will rendezvous at Barclay Plumbing on the morning of the 16th, and I will give the specific time in our schedule when we get to that point. So nothing else, if there's nothing else for today. Oh, I did want to say one other thing on the site visit. The San Manuel Band has also requested a list of parties, of people who will be attending, and we certainly have to respect that because it's their property. So I will ask for basically everyone to list 3 different times. Are you going, maybe 4? Are you going on the morning hike and the afternoon hike the first day? Do you want to go on the helicopter ride? And do you want to go on the San Manuel Band? So we'll probably end up with 4 lists. Obviously, there'll be a lot of overlap, but I think that'll be the best way to avoid any confusion. So thank you all very much. It's been a long process. I think we're making progress. We'll get through the site visit and then address the rebuttal phase and potential motions, and we'll go forward. So with that, everybody have a good day, and I'm going to sign off. Goodbye.